Imagine for a second that all of your casual text messages, your private emails, and your daily location data are being quietly scooped up and analyzed without anyone ever having to ask a judge for a warrant. It sounds like a plot from a futuristic thriller movie, but this is a very real debate happening right now regarding the surveillance laws in the United States. A long-running legal provision that allows intelligence agencies to collect massive amounts of overseas communications is set to expire on April 20, and lawmakers are completely deadlocked over what to do next. The law in question is known as Section 702 of the Foreign Intelligence Surveillance Act, or FISA for short. On paper, this law was designed to allow the National Security Agency, the CIA, the FBI, and other federal groups to monitor overseas communications that happen to flow through U.S. networks. The catch is that they do not need individualized search warrants to do this. Because they are sweeping up so much of the global communication flow, they also end up collecting an unfathomable amount of information on everyday citizens who just happen to interact with people overseas. This includes private phone logs, emails, and text messages. Many privacy advocates argue that this collection happens despite constitutional protections that are supposed to shield people from unwarranted government surveillance. As the expiration date approaches, a bipartisan group of lawmakers is demanding sweeping changes. They argue that these reforms are absolutely essential to protect privacy rights following years of debated surveillance practices across multiple administrations. Meanwhile, others want to push through a simple extension without any changes at all. In fact, a recent social media post from the White House indicated they support a clean reauthorization. Just recently, the House approved a very brief stopgap measure to extend the law until April 30, just to buy a little more time for negotiations. The Senate still has to vote on this short-term fix. The group pushing for changes has introduced the Government Surveillance Reform Act. One of the biggest things they want to fix is a loophole known as the backdoor search. This loophole currently allows government agencies to sift through the communications of citizens without getting a warrant first. Another massive issue they are trying to tackle involves commercial data brokers. Right now, app developers collect huge amounts of location data from your smartphone and sell it to data brokers. Those brokers then sell that exact same data to governments and military organizations. The FBI director even confirmed in a congressional hearing that the agency buys location data without seeking court authorization. Both sides of the political aisle seem highly interested in closing this specific loophole, especially since new technologies make it incredibly easy to analyze billions of location points in seconds. This is also a major sticking point in ongoing negotiations with major tech companies regarding the unrestricted use of their tools. Privacy groups, like the American Civil Liberties Union, strongly support these proposed reforms. A prominent senator who has spent years on intelligence committees has even warned that the government relies on a secret legal interpretation of this law that directly affects privacy rights, urging for that information to be declassified. Even if the law does technically expire on Monday, a legal quirk means the actual surveillance could continue until March 2027 because of how the Secret of Oversight Court certifies the programs annually. It is a highly complex situation that highlights just how hard it is to balance national security with personal privacy in the modern digital age.